from the Delta Petroleum Caribbean Limited.
Yes, Mr. Guthrie.
Yes, my Lords, in this appeal, I appear on behalf of the Commissioner, my learned friends Sir Fenton Ramsahoy and Ms. Naina Patel appear for Delta, the respondents. My Lords, I will make the usual assumption, if I may, that your Lordships at least have had some opportunity to find out what this appeal is about.
Well, we've read the papers, and in as much as that tells us what it's about.
Well, I shall try and be as economical with them as I can.
Yes, well, we didn't think that it would occupy very much time, Mr. Guthrie.
Well, let's hope not, my Lords.
No.
The Commissioner seeks to restore the decision of the judge, Mrs. Justice Ellis. Her decision was made on the ground that the fuel concerned was subject to forfeiture under Section 31A of the Customs Act because it was dutiable upon its discharge into a particular storage tank and the duty had not been paid.
Yes.
She found that the exception for fuel intended for use by the British Virgin Islands Electricity Corporation didn't apply. The Court of Appeal considered in fairly short order that the exception did apply, and it's that difference of opinion which is at the heart of the appeal.
She was obviously very unhappy with reaching that conclusion and thought
Yes.
that it ought to have been sorted out administratively.
Yes, and I don't blame her for thinking that. The question is whether she was right in thinking that the law was the law and she had to apply it as she found it.
Well, that obviously is the issue we have to decide, but you're not going to tell us any more about why this is being pursued.
No, I'm not going to tell you any more about that. And my instructions are to pursue the appeal, and that is that. The record, I'm afraid, although it's short, is somewhat less easy to follow than it might be, because proceedings were commenced by both sides. Perhaps I can just identify the principal documents underlying the proceedings. The first is the Appellant Commissioner's Notice of Seizure, which you will find at pages 72 and 73. And I'm hoping and I'm assured that the numbering is the same in the electronic as well as the paper record.
That's good start.
Grounds were at that time stated to be that the discharge had been without customs supervision, contrary to a provision of the Act. The respondent Delta...
Without permission or supervision is what it says, isn't it?
Yes, yeah. Delta promptly notified the Commissioner of its objection, which you will find at page 74. That's in the form of a letter from McW Todman and Company, and that complied with the procedure for notifying an objection. And I can tell your Lordships that although a good deal of the bickering, if I can say that, in the court below concerned the adequacy of the notice of objection, we don't quarrel with the judge's finding that it was satisfactory in the circumstances. It was followed on the 1st of November 2012 by the Commissioner's Notice of Application for Condemnation, which is at page 79 of the electronic record. And the point made by the Commissioner, which remains to be considered by this appeal, is on page 81, paragraph 3b, where it's set out that the portion of fuel contained in the tank amounted to imported goods, being goods chargeable on its importation and with a duty, and without payment of that duty, it was unloaded and removed from the place of importation. And thereafter, Lords, the Commissioner issued proceedings for forfeiture by a fixed date claim form which is in the record at page 131. There was inevitably some duplication of the evidence put in the context of the cross-applications, if you like. There is a brief summary of how things were worked out procedurally at page 221 in the course of the argument in the Court of Appeal. It was set out by the respondents, the present respondents, in the context of their application for cost, but one sees that...
Which page was that again?
Page 221. One sees that they were pointing out that the first thing that had happened was that they had filed an appeal, by which they mean the notice of objection to the notice of seizure. They say because at that time they were desperate, we wanted as quickly as possible to have the matter heard. Subsequent to that, the respondent filed the condemnation application. So you had two proceedings on the same matter, the appeal and the condemnation. We said, well, can we just join both so that in one determination was made? The respondents objected. They said, no, it was different matters, you couldn't do that. And in the end of the day, we were faced with a situation we had to abandon our appeal in order for this matter to go forward. That, of course, saved time. And then they complained that we had the wrong procedure. But I think all your lordships really need to know is that one way or another, the parties' various contentions all came before the judge at the same time, which led to the judgment which we will look at in due course. That means, I'm afraid, that I may have to ask you to bear with me if I move about a bit in the record. What I propose to do is go to the matters on which the appellant relies in what I hope will be a convenient order. I should mention one matter now. It seems that the record omitted some material. I think this was probably intended deliberately to avoid duplication, but at all events I was sent last night a copy of a second affidavit sworn by Mr. Bevis Sylvester, who is Delta's regional general manager. I hadn't seen it before, and I can't say why it was omitted. It was certainly the appellant's obligation to have the certification arranged in the British Virgin Islands. Then it would have become the parties' joint obligation to make sure that the relevant documents were all before your lordship's board. Unfortunately, I haven't been able to take any detailed instructions as to why that affidavit isn't there. I had hoped that the Commissioner would be here, and indeed he hoped he was going to be here, in which case I could have sorted it out quite quickly. But due to unforeseen circumstances, I also found out, in fact, this morning, that he isn't going to be here.
But was this affidavit before the judge, Mr.
Well, I think
Guthrie, or not?
Well, that's what I'm unable to say, but I assume that it was. I think it is referred to.
She tried it on affidavit, didn't she?
Yes. I think she must have had it, and also one of the documents exhibited to it is referred to, which is a letter from 1992.
Well, there are some documents exhibited to this which are referred to in other people's affidavits.
Well,
most of the time we've seen them.
I think you've seen them, probably seen them all. There's one letter which I think my learned friend...
We certainly haven't seen the manifest, which is towards the end.
Yes, and I think also there's a reference in the judgments to a letter in 1992 which set out some original arrangements for payment of duty, which I hadn't seen before. But perhaps because I haven't had very much... It certainly didn't seem to me that the affidavit and its exhibit altered the position in any very fundamental way. But perhaps because it's a document which is produced by my learned friends, I can leave it to them to deal with it if they want you to look at any particular parts of it. And I will, so to speak, develop our points without reference to it for the time being at all events. Well, I've already referred your lordships to ground 3 of the appellant's notice of forfeiture, which refers to the non-payment of duty as the basis upon which the Commissioner would rely. Also, having mentioned the affidavits, perhaps I can just highlight the fact that the case did proceed entirely on the basis of affidavits. There was no oral evidence or cross-examination before the judge. The claim for forfeiture was supported by the Commissioner's evidence. It won't be necessary to look at very much of it, but I wonder if I can take you to the principal matters which were relied on. The first affidavit is at page 90. To make matters worse for me, the index refers to the wrong date for that. It was sworn on the 2nd of November, not the 12th of November. But you'll see that the story really begins at paragraph 5, where the Commissioner describes how the Customs Department has, over a number of years, sought the respondent's compliance with the Territory's requirements for the importation of fuel. That then refers to the letter dated the 21st of 1992, which is one of the documents which is now available for the first time. But the situation had changed. Recently, the Department of Customs held meetings with all importers of fuel to inform them of the requirements for the importation. The respondent was represented at the meeting. Following the meetings, the Department of Customs issued written directions for the importation of fuel to all the fuel importers. A letter containing the directions for importation dated the 23rd of July 2012 was sent by the Department of Customs to the respondent, and a copy is at WS1. My Lords, perhaps it's sensible to look at that at this point. It's at pages 97 and 98. It begins at page 97 by saying why it was intended to introduce a new system. In the first paragraph, in a recent meeting, a number of conditions for the import of fuel into the Territory were discussed. In addition, a new procedure was discussed which will eliminate the need for Delta Petroleum to submit requests for refund of duty on fuel sold duty-free. It's expected that your office is already making preparations for such procedure. The point is effectively that it's the case that the first responsibility for the payment of the duty is on Delta, who are after all selling it to BVIEC. At the end of the day, arrangements would be made for the refund of the duty paid. On the next page, perhaps I need only pick up the third of the bullet points. Imported cargo will be permitted to be released on a bond where necessary, provided that such bond is approved by Customs and remains current. In the case of duty-free entries, an authorised person from the eligible entity must stamp and certify that the cargo is for the sole use of that entity. All cargo released on bond during the previous month must be cleared by the 10th day of the current month.
So if that were carried through, that would need a stamp from the electricity people, would it?
Yes.
Right.
If this new procedure was to work, it required a number of formalities, but that's certainly one of them. But you'll see that the judge picks this up. Although it may have been rather convoluted, it was necessary to realize that the importer of the fuel is the person who is responsible for the payment of the duty in the first instance. Where it's duty which is intended for the use by the Electricity Corporation, then there is an exception, but it doesn't kick in automatically. And that, one might interject, is only common sense, because Delta is a fuel company which is selling fuel. The evidence is that it doesn't only sell fuel to the BVIEC, but otherwise. Obviously there has to be some arrangement which takes account of that. And we'll see in due course that Delta remained the owner of the fuel under the contract it had with BVIEC.
Sorry, say that again, please.
Well, we'll see in due course that Delta remains the owner of the fuel and under the contract, we can go to straight away if it's...
Remained until what time,
Well,
owner of the fuel?
Well, that's what I'm just about to show you.
Very well.
It's page 23 of the record, which is an exhibit to one of my learned friend's clients' witnesses' affidavits. That is the agreement. It begins at page 19, where you'll see that BVIEC is the buyer and Delta is the seller of fuel. And on page 23, the third paragraph on the page, Title 2 and risk of loss of such delivered volumes of number 2 diesel fuel delivered to the Pockwood Pond Power Station shall pass from the seller to buyer at the point where such delivered number 2 diesel fuel enters the buyer's pipeline located at the Pockwood Pond shoreline if delivered directly from the seller's vessel, or at the buyer's storage tanks if delivered from the seller's depot.
Sorry, which page of...
23. The third paragraph down.
All right.
Oh, yes.
Begins Title 2 and risk of loss. Or at the buyer's storage tanks if delivered from the seller's depot.
What does that mean in relation to the present case?
Well, it must mean, I think, delivery to the storage tank, because what happened...
Well, sorry, which storage tank? Do you mean tank 7?
Yes, because that's what...
The buyer's tank, is it?
Well, it's the status of that tank.
Earmarked by Delta for fuel that is going to the buyer.
Yes, that's right. But it's plainly what happened. I don't think this is controversial. Is that the seller couldn't deliver it other than by the use of one of its other fuel lines from another vessel.
Had to borrow a hose.
Yes, exactly. Yes, I had to borrow the hose from the Ocean Princess.
Yeah. Well,
But the point being that it is when it comes, it still belongs to Delta.
I'm sorry. At what point are you saying that the fuel becomes in the ownership of the electricity company?
When it is in the tank.
Tank 7.
Yes.
Really?
Yes, I think so.
Right.
Yes.
And there you're being
Well, I
totally
think,
faithful.
well, that's according to the terms of the contract.
And you're being
may I-
totally faithful to what your predecessor, the Attorney General, said to the Court of Appeal at 197.
Well, I'm not
If we
exactly
can just
sure.
look at that, Mr. Guthrie.
Well, we're going to look at that.
Could we just look at it now?
Yes, of course. Yes, of course.
97.
Which page?
197. The Honourable Justice Michel. So when the fuel reaches the tank, the designated bonded tank, it's the property of the electricity company. Answer, it's the property of the electricity company, which is precisely what you said.
I think it is. Yes. I mean,
It is.
Yes. Yes.
Think about it.
Well, the only reason I say I think it is I don't think it's altogether clear what the Attorney General meant.
What are you
throughout.
submitting, which is rather more important?
Yes. Well, I'm submitting...
You just submitted that is what it...
It remains, it's the ownership of Delta when it arrives. It becomes the ownership of the BVIEC when it gets into the tank.
What do you mean by arrives?
At Pockwood Pond, because it comes to the British Virgin Islands. You'll see in the evidence that a distinction is made about this. And I appreciate I've been, no doubt, I hope helpfully brought forward. But I'm going to look at the evidence as to what the Commission said about this.
When do you say the liability to duty arises?
When it arrives at the into the territory.
In other words, sorry, yes, but when's that?
That's when it arrives at the Pockwood Pond, at a point before it is transferred from the vessel.
While it's still on the ship?
Yeah.
Once it's in territorial waters?
Well, I don't think I've thought of it in terms of territorial waters, but...
I think you'll find that's what your regulations say.
Anyway, I'm afraid I have another
Either way, it
fix.
doesn't matter. You say while it's still on the ship.
Yes.
Once it's in port.
Yes, once it's in port. Yeah.
Then the duty is due, is it?
Yes.
it's even before the Delta becomes the owner of it.
Delta's the owner of it, yes. Well, the obligation for the payment is on the owner, but the obligation for forfeiture is on the non-payment of the duty.
Yeah, well, I appreciate all of that, but looking again at page 23, the third paragraph, title to the fuel shall pass from the seller to the buyer at the point where such delivery enters the buyer's pipeline.
Yes, well, it never did that.
The buyer there is
The buyer is the BVIEC.
the electricity company.
Yes.
Delta is the seller.
Delta is the seller.
Delta's got it on the boat.
Yes.
Yes.
And Delta has it while it's in Delta's pipe, and it becomes liable to the duty when it gets to, at a stage before it actually gets into the tank, as I understand it.
But why, I mean, this says it only becomes the electricity company's oil when it gets into their pipeline. That presumably is after it's been in the tank.
That's if it's delivered directly from the seller's vessel into the pipeline. That envisages a different situation where the seller, the buyer, where the seller can, so to speak, get straight into the grid, if you like, rather than going through the intermediate stage of tank number 7 or whatever tank it happens to be.
So you're treating this as a case when it gets into the buyer's storage tank, and tank 7 is their storage tank. Is that the idea?
Yes, yes. Well,
Is that right?
well, the evidence about the status of tank 7 is one of those areas which appear to have been disputed. But
Yes, but as my Lord Wilson has pointed out to you, the Attorney General has said that it's the property of BVIEC when the fuel reaches the tank.
oh, well, that rather begs the question of whether it's in the tank or reaches the tank, as I understand it, means that it's in the tank.
Yeah.
So I don't think there is anything inconsistent.
But that you're happy to, I mean, the judge and both the judge and the Court of Appeal clearly proceeded on that basis,
Yes.
didn't they? Because they were told that by the attorney.
Well, the attorney wasn't involved in front of the
Court
judge.
of Appeal.
He told the Court of Appeal that, but I think it also
You're
follows
telling
from
us
the
the
terms
same.
of the contract.
And you're telling us the same.
Yes, and I think it follows from the terms of the contract.
Well, we don't need to construe the contract if you tell us that.
Well, there is still possibly an issue as to the status of the tank.
That at all.
Yes, and once the fuel's in the tank, how do you identify the forfeitable goods?
The profitable goods.
The forfeitable.
The forfeitable goods. Well, you don't have to, but that's why Section 132 exists, because the Act provides for what happens if it's mixed.
Yeah.
And then I'm afraid Delta suffer by having done this, because the whole of the contents of the tank become forfeit.
Well, that's why it's such a draconian remedy, isn't it?
Yes,
because if in fact all you'd done was to put a couple of gallons into tank 7, which belonged to BVIC, and there were other fuel in there which didn't,
yes.
They'd lose the lot.
Well, that is correct, but the judge said why there had to be a draconian.
No, I can see that.
And we would submit that she quite rightly directed herself that wasn't something that she was entitled to interfere with if the law made it clear what had to happen.
Yeah.
And that is the stance that the Commissioner takes.
And presumably the oil that was already in the tank with which the new oil was mixed was also the property of the electricity company.
Well, yes, I'm not sure that's entirely clear on the evidence, but it certainly would appear to be likely, yes.
Well, if what the attorney told the Court of Appeal is right, it must apply equally to the stuff that was there before.
Well, we're going to come and look at the status of the tank, so to speak, but it doesn't seem to have been a bonded tank in the sense that bonded means subject to a financial guarantee. But it appears certainly to have been an earmarked tank.
Well, it was described as a bonded tank
It
by
was.
everybody for the very good reason that's how it's described in Clause 3.5 of the contract.
Well, you're absolutely right, but
But you say there isn't, it isn't,
yes,
it isn't,
it
isn't supported by financial guarantees.
it's not supported by a financial guarantee, but it is an earmarked tank,
Yep.
and no doubt that most people wouldn't have sought any need to distinguish those two situations in daily life. I mean, but there we are. I was at page 90, which is the Commissioner's evidence, and taking you to that letter and thereafter from paragraph 6. There's then reference in paragraph 7 to the fact that there had been a previous visit by the same vessel which had, I think, effectively been winked at, and it may be that the fact that this was a second occasion informed the Commissioner's stern attitude, but I'm not it's not right for me to say that categorically. On the 29th of August, we come to the relevant visit of the Charmer, entered the Virgin Islands, a copy of the relevant manifest. That's, I think, at page 99. You'll see that refers to there are two.
That says it isn't for the oil, for the electricity.
Yes, but it also has an entry for...
Which page are you on now?
Page 99. And also, I think that there are inconsistent documents which have been produced yesterday, so to speak. Well, at the very least, it's not particularly clear, and I don't think it's necessary to my argument whether it was apparent that it was for the...
And then let's move on then.
Yes. The story is really taken up over the page. No permission or notification for the discharge on the 29th of August. Then the fact that Customs had attempted to insist, and then the notice of seizure refers to a requirement of the Department of Customs in paragraph 11. The acceptance that they should have been notified. Then if I can just go to read paragraph 12, I know that the way in which the tanks at Pockwood Pond are configured, fuel can move to and from tank number 7, a tank usually reserved to hold fuel destined for use by the British Virgin Islands Electricity Corporation to other tanks. Thus, tank number 7 is said to be a bonded tank, which means it is a reserve tank, as there is no financial security in relation to the tank, as is envisaged by the relevant legislation's use of the word bond, brackets bonded. Additionally, fuel in tank number 7 can be diverted to other use. Indeed, fuel in tank number 7 becomes duty-free when the British Virgin Islands Electricity Corporation verifies that the fuel was reserved from its use.
Well, that's what he says.
Yeah.
The contract says, of course, he's not a party to the contract. No. The contract says, between you and the electricity company, that the customs shall have the keys to the tank.
Yes.
And presumably, well, I say presumably, perhaps you did.
Well, that seems to be one of the matters which wasn't fully cleared up.
Right.
But perhaps
it also says that the tank, as a matter of contract, the tank will be used only for the electricity company's fuel, doesn't it?
Yeah. Well, one obviously wishes that there were some loose ends, but I'm afraid I have to work with what happened in the British Virgin Islands, and some loose ends were left. Perhaps I can go on to the subsequent affidavit to the Commissioner, which is at page 109. And it's at a fuller account, effectively, particularly from paragraph 16. And he refers first to the previous July visit and says that the Customs absence have been drawn to the respondent's attention. He says the respondent knew that observation and permission must be observed, the requirements. In particular, the customers were to be notified. And he says at paragraph 19, approval of discharge of fuel from tank number 7 to the British Virgin Islands Electricity Corporation was distinctly separate from the permission to discharge fuel from the vessel Charmer to tank number 7.
Well, how does that square with the fact that the Electricity Corporation owned the fuel when it was in the tank?
Well, presumably they still had to account to the customs for it when they took it out. And then he expands over the page. It says again, fuel can move to and from tank number 7. Thus, tank number 7 said to be a bonded tank, etc. Makes the same point again. He says, I know the Department of Customs cannot verify by calibration on the automatic electric meter system used by the respondent to determine the amount of fuel in respective tanks. The automatic electric meter system is not controlled by Customs. As far as I'm aware, the Department of Customs received no notification, etc. I have the right to take appropriate actions. In paragraph 23, it's a requirement for the department to give approval for fuel to be discharged in the Virgin Islands. The respondent doesn't deny that permission was not given for the discharge of fuel from the Charmer and admits that the Assistant Commissioner informed Mr. Letsom that Customs should be present. I believe, therefore, the Department of Customs acted to seize the tank and fuel and other fuel mixed therewith in accordance with law, given the indication that it was made. Well, he takes up the story there, refers to a meeting with Mr. Sylvester, and the issue of the notice of seizure on the 20th is at paragraph 26, and he says there were further attempts to resolve it, but they didn't come to anything. I don't think I need anything further. His evidence is supported by an affidavit of the same date by Mr. Perry Smith. It is the case that there are other, there are affidavits in exactly the same form, which have not been included in the record, but I don't think they contain any different information. The paragraph 5 refers to the first visit in
Which
July.
page are we on now?
Page 119, I'm sorry. Paragraph 7 refers to the visit in question. He says in paragraph 13 on page 121, the manifest should indicate the correct destination for the fuel. The manifest shown to me, which designated the arrival of the Charmer on the 29th of August, indicated that 122,000 US gallons of fuel was designated for Delta and 0 designated for other entities listed on the manifest. And that's a reference to the document that I've already shown you at page 99. It may be that there are other manifests which indicate something different, but at the very least, the paperwork seems to have been sufficient to cause any reasonable customs officer some concern. The final piece of evidence from the Commissioner's side is at page 124, which is the affidavit of Mr. Romney, who's the Assistant Commissioner. He deals with the July incident in paragraph 5. In paragraph 6, he says this, and this doesn't seem to have been contentious. Indeed, the judge will refer to this, as we'll see in a moment. He says in paragraph 6, refunds are given to the respondent after it sells fuel duty-free. Thus, the respondent is aware that fuel is not automatically duty-free on importation. Fuel is duty-free when it can be verified that it was sold on a duty-free basis. He then refers to the fact that he should have been informed and wasn't of the discharge of the fuel. Paragraph 13.
Well, you say wasn't. There's no dispute is that Letson was doing his best to phone him, but didn't get through.
Well, certainly there's no dispute that attempts were made to, but those attempts were unsuccessful.
Yeah.
And as the judge said, she was rather surprised in those circumstances that Delta took it upon themselves to go ahead willy-nilly. And if they did,
Well, is there any explanation as to why it was impossible to get through?
I'm not sure if I can answer that question immediately. I don't think.
I mean, it was weekend. Nevertheless, Mr. Perry-Smith was officer for the weekend, so you can't say that the customs, as it were shut down then.
Yeah.
Can you?
No, but I'm not going to stand here and say I don't have any sympathy for Delta either, because I can quite understand that it was a difficult situation they were in. But the law is there, and if they were unable to notify, they should have waited until they could.
Well, does that mean that they'll have to wait indefinitely?
Well, obviously not with respect. It was only a question. It seems to have been as much a matter of convenience because they had the Princess hose available. I mean, I don't think it would be fair to draw every inference against customs on this basis. I mean, we don't know whether after telephoning they couldn't have done something else, or say in advance of doing it, we are proposing to do this, we have been prevented from getting in touch with you.
Well, if you're right, it doesn't actually matter whether Mr. Letson tried to get in touch with Mr. Romney or not, does it?
No, it doesn't.
If you're right.
Yes. Well, yes. I mean, I don't think it does matter.
Is it consistent with Section 69 for goods to be dutiable when they're imported, but then the duty to be reimbursed subsequently?
Sorry, with Section 69.
Section 69 is page 391. What I'm wondering is, it says that the goods which fall within the following classes may be imported free or partially free from duty, and they're imported, we know from Section 3 on MS 342, when they come within territorial water.
Yeah. Well,
so when it has territorial waters, either they're imported free from duty or they're not.
well, one has to remember, I think, that Section 69 begins with certain prefatory words, which is subject to conditions as may be prescribed by the Commissioner.
Yes, but the conditions must be consistent with what follows. The words may be imported free.
Yeah. Well,
But that's goods which are imported by or on behalf of the electricity company,
yes.
which these weren't. I mean, they were imported by Delta.
That's one of the questions I
Well,
suspect
that is
address.
yes. Well, that's what we say.
Maybe
Yes.
the main question.
If I may say so, one hears what the Attorney General told the Court of Appeal. One also can look and see what Delta told the Court of Appeal. And if one goes to page 206,
No, but I mean, if they're imported by the electricity company, then they're clearly not dutiable under these provisions.
yes.
You lose.
But I think it's I was going to go to page 206.
Can I just ask you before we leave this point? I mean, do you accept the point or not that in order for relief from duty to be consistent with Section 69, the relief must apply at the time of importation?
Well, if the importer is BVIEC, yes, but not if the importer is Delta.
Yes, well, whoever it is. I mean, either the relief applies at the time of importation or it doesn't.
Yes, if the relief is applicable.
Yeah.
Yes. Well, I think that must be right because But again, the Section 69 has to be remembered as being introduced by the introductory word subject to conditions may be prescribed by the Commissioner. So even if it was imported by the...
But that also applies to Section 20 of the Electricity Corporation Act, which talks about goods imported by the corporation being free of duty.
Yes.
Not goods sold on to the corporation after importation.
Yeah. Well, if I can just remind the board of what Delta said in the Court of Appeal at page 206. He said, the corporation, this is at line 5, of course, is not an importer of fuel.
Yes, but going back to section 69 1D, goods can be imported on behalf of a person entitled to relief.
It's an interesting juxtaposition of two sentences. The corporation is not an importer, it imports fuel through a second party.
Right. Or the concession was it wasn't it didn't have boats itself. It had to do it through an agent. They were still importing, Mr. Neal said, but through Delta.
Well, my Lord, as is always the case, these provisions are receiving a great deal more detailed consideration here than they did.
If, Mr. Guthrie, if Delta shipped the stuff to the British Virgin Islands on behalf of the electricity company, would it be dutiable or not?
Yes, it would be.
Would it?
According to the Commissioner, it would, yes.
Why?
Because, well, no, wait a minute. If the importer is properly to be considered the importer, then it could take advantage of the concession, provided that it complies with the conditions which are imposed under the Act.
Follow that.
So
but in principle...
In principle, the concession is there and available to BVI.
If you say concession, that's Section 69.
Yes.
It's not a concession, it's a statutory entitlement.
Yes, you're...
Well, I mean, we need to be clear whether we're talking about a statutory entitlement or an extra statutory concession.
Yeah.
And I think we're talking about a statutory
Yes, well, I'm afraid I'm falling into the error which others have fallen into in this case before me of referring to it as a concession when it probably shouldn't be.
An acceptance of the legal position.
Yeah.
Right. Well, where do we go from there?
Well, I was going to leave... Oh, there was one final part of the evidence of Mr. Romney, which is his reference to the awareness of the... sorry, I've lost my place. It's...
Mr. Romney's at
124, his affidavit started. It was only his reference at the end to the acceptance by Mr. Letzam that he had been in breach of regulations, and that particular email is at page 69 of the record. And he apologises for the fact that the formalities weren't gone through.
Where is that?
Page 69. Yeah. It's an email dated this.
Yes, I got that.
He says, I would first like to apologise, spelt wrong, for the late submission of this correspondence. I wasn't going to read the whole of the email, but it says he accepts that the relevant documents, etc., had not been submitted, and said they would be submitted in due course. My Lords, perhaps I can go to the judgment, much of which we needn't look at because it no longer is important. I was going to just go to paragraphs 37 and 38 at page 142 of the record, which sets out the two bases upon which the Commissioner is arguing his case before the judge. And it's paragraph 37, which still is alive. The applicant contends that the fuel in question was dutiable, i.e. subject to duty on their importation, and was without payment of such duty removed from its place of importation at Pockwood Pond and offloaded into tank number 7. So that identifies, certainly as far as the judge is concerned, the place of importation as being Pockwood Pond, and then it being offloaded at Pockwood Pond.
Which paragraph again?
37.
Thank you.
And then 38, if I can just quickly read that. The applicant also contends that the fuel is liable to forfeiture because it was imported, offloaded and landed contrary to restrictions contained in directions issued by the applicant, which were in force with respect to the importation of fuel. Those directions are referred to in paragraph 41. And that's original directions, 21st of January 1992, later on the 23rd of July 2012, imposed conditions in respect of importation of fuel into the territory. And I don't think I need read the next part because you've seen the relevant letter. It's just worth looking at paragraph 45, where the judge says this: the respondent does not dispute the fact of and validity of the written directions in question. And the respondent's evidence discloses that prior to and during the offloading process, repeated efforts were made to contact the Assistant Commissioner. These all proved futile. The respondent...
Mr. Guthrie, are you still relying on the directions?
Well,
I mean, we know you're relying on Section 30. That's not directly related to directions. We know that Section 29 is really the directions section and can lead to an offence. But that's not what we're talking about on this appeal.
No,
can you clarify that?
No, it is... That's correct, my lord. But it is perhaps important to see how matters developed by just making... I'm only making this passing reference to the fact that it was accepted by the respondent that the directions applied and that the fuel was discharged in the absence...
But the directions are not a link in your argument about entitlement to forfeit.
No.
Very well.
I mean, I'll have a little bit more to say about the notice of seizure, perhaps, but no, the entitlement to forfeit is firmly based on the non-payment of the duty.
Thank you.
Yes, 31A.
Yes. We know that, I mean, I mention that only in passing because we know that the judge found that the separate approach which the Commissioner had made at first instance wasn't justified, and I don't think I need waste your time by saying why it wasn't. But we accept that her decision in that respect, and her reasons for finding in our favour begin at paragraph 56 of the judgment, which is at page 145. Yeah. And I think it's... if I can just direct you to what she said about that. She says at paragraph 56, it is not disputed that the respondent company is an importer of fuel and is engaged in the business of retail and wholesale distribution of petroleum and petroleum-related products in the territory. It is also not disputed that the company imports fuel intended for the use of the British Virgin Islands Electricity Corporation, as well as for its own commercial use. The parties also agree that while fuel imported for and on behalf of BVIC will not generally attract customs duty, any fuel otherwise imported by the respondent company would. The applicant contends that regardless of the intended user, fuel is not automatically duty-free upon importation. The applicant's evidence is that the established procedure where fuel is imported on behalf of the BVIEC dictates that any duty on the fuel intended to be sold to the BVIEC is to be paid up front by the defendant company. Once Customs Department is presented with evidence verifying such sale, then the duty which has been paid is thereafter refunded to the respondent. This rather convoluted procedure is apparently under review by customs officials, who have as not yet prescribed an alternative process. However, presently fuel intended to be sold to the BVIEC only becomes duty-free when it is clear that the fuel has been sold on a duty-free basis. This is not disputed by the respondent. So this is the basis upon which the judge proceeds.
The potential confusion there, isn't there, Mr. Guthrie, between the expression imported on behalf of the BVIC in 58 and fuel intended to be sold to BVIC in 59. They're not the same, are they?
Well, no, but no, it can be resolved in favour of the respondent on the basis that it is imported by Delta, intended to be sold, and that she has elided those two things. That's what we say.
Is that it was imported on behalf of the electricity company. That's the whole issue, as far as I can see.
Well, it's certainly.
Yes, I mean, it rather looks as if 58 and 59, the argument is getting confused. The issue, really, of liability depends on whose behalf the oil is being imported.
Well, subject, and this is where the directions are a part of the argument. They aren't, so to speak, a necessary basis for the forfeiture, but they are a part of the argument because it is only in that circumstance that the duty would be refunded according to the procedure which everyone agreed apparently applied. Well, my lords, we see what the judge thought the position was. She goes on to describe our case, which was at the time the fuel was removed from its place of importation and offloaded. So she's making the distinction between the place of importation and the loading into tank number 7. I think it means a tank located on property owned by the respondent. It was in fact dutiable, and the Commissioner contends that this removal occurred without the payment of the relevant duty, and therefore contrary to section 31A(3), which she then sets out without the unnecessary words.
I mean, the argument, that the position of the Commissioner appears to be that the conditions which he can impose under section 69 entitle him, can include conditions requiring payment of duty to be made in respect of non-dutiable goods. When one looks at 58, the established procedure is that the duty has to be paid up front, and then subsequently it'll be reimbursed.
I think he would say that they were dutiable goods, which only became non-dutiable when they became the property of the electricity corporation.
That can't be right, because
well, that's what he said.
Because we've seen they're either dutiable or not on importation.
Yeah, I mean, the alternative view, it may be, I mean, this hasn't been suggested, that technically they're dutiable when they come in because they're brought in by Delta. But as a matter of concession, it's accepted that if they're in fact imported for the electricity company and you comply with these directions and this system, then they'll be treated as though imported on behalf of the corporation. I mean,
well, as I understand
that would be a sort of logical way of dealing with it.
Well, I mean, that's the convoluted way of dealing with it.
It's not necessarily, I mean, it's a tenable way of putting it, which so far no one seems to have...
Well, I have sorted out as to whether actually money was paid by Delta into Customs' bank account and then paid back. And I was told that it was an accounting exercise rather than an actual. But I mean, so I think that's what probably happened.
Yeah.
Yes.
But I mean, the trouble is, it's one of these situations where the parties have developed practical arrangements which have probably worked perfectly well for years, and then something sort of goes wrong, and you try and sort of reanalyze them in terms of these precise sections which don't really fit.
Well, I think I can't really sensibly say that that's not a fair way of looking at it.
It doesn't make it any easier.
But the judge, well, we could see her approach to it. She deals with the point about the tank in paragraph 61. She says the Commissioner puts no store in the fact that the fuel was purportedly discharged into what has been described as a bonded tank. Although it's clearly identified as such in the notice of seizure, it's not in fact a bonded tank, Counsel submits. That's Counsel, noted that not only is there no financial security in place, as required by Section 103 of the Customs Act, it's also not in the position and control of the Customs Department. The tank in question is simply used to deposit fuel intended for use by the BVIC and is open and accessible to the respondent.
If it's of assistance, we have read the judgment, Mr. Guthrie.
Well, my Lord, well, in that case, perhaps I can take it fairly shortly.
Yes.
I did want to look, though, particularly at paragraph 70, because that is a paragraph on which my learned friend's case focuses on. The judge said, in this case, both parties agree that unless otherwise mandated, petroleum fuel and petroleum-related products are subject to customs duty upon importation into the territory. It is also accepted that the BVIEC has been granted a duty-free concession in respect of fuel imported for its use. However, the applicant contends that the practical import of this is that the fuel is not automatically duty-free upon importation. The applicant's evidence is that the established procedure where fuel is imported on behalf of the BVIEC dictates that any duty on the fuel intended to be sold to the BVIEC is to be paid up front by the defendant company.
If I can just interrupt you there, isn't it implicit in that sentence that the defendant company is importing the fuel on behalf of the BVIEC?
You can't have both, can you? You can't both be being imported on behalf of BVIC and intended to be sold. It's either theirs or it isn't.
Well, it's imported for its use.
Oh, yes.
But it is intended to be sold. Why is that inconsistent? I mean, I'm sorry, I shouldn't be asking you questions.
You say they're not inconsistent at all. Okay.
Once the Customs Department is presented with evidence verifying such sale, any duty which would have been paid would then be refunded to the respondent. Now, my learned friend's case, which I can give you the reference to it, but I think perhaps not necessary to go to it, he says that that is an impermissible or totally unacceptable, unarguable, I think is the word that he uses, view. The reference is at page 322 of the electronic record.
Internal page number?
I think...
Paragraph number?
Paragraph number 10.
Thank you.
And MS 322 on page 4.
And it must be implicit in the acceptance that the oil, once it enters the tank, is the property of the Electricity Corporation. The property passes before payment of a sale price has necessarily taken place.
Yes, but why would payment of the sale price make a difference with respect? The payment by the BVIEC to Delta would presumably be dealt with on a monthly account basis or somewhere like that, but why it would not make any difference to this. But no, the words that the learned friend, I think it was Mr. Richards at that stage, who was unable to be here today, says such reasoning is with respect to unsustainable.
Well, he goes on to explain why it's unsustainable. Because he says it's a question of law, not a question.
Yes.
And he also queries the basis, in fact, asserted by the learned judge for her conclusion.
Well, but what it doesn't acknowledge with respect is the next paragraph in the judgment, which is that these things weren't disputed by the respondent. That's in paragraph 71.
Yes, but that doesn't sound on the question of whether it's a question of law or not. I mean, do you accept that it is a question of law?
Well, it's both, is it not? We see is the application of the law to the facts of the importation of the fuel. And, if I can just say that at the same point in the case, or just earlier, the respondents rely on Section 20, not only on Section 20, subsection 1 of the Electricity Ordinance, but also Section 69(1)(d) of the Act, which we've already looked at, and underlines the words, goods which fall within the following classes may be imported free or partially free from duty. Goods imported by or on behalf of a person entitled to full or partial relief in respect of the goods. But that is expressly made as being subject to conditions as may be prescribed by the Commissioner, so that if I'm an importer, such as Delta, and I'm importing on behalf of the BVIEC, then that part of the Act is expressly made subject to the conditions imposed by the Commissioner, and that is what the Commissioner had done. And it's those conditions which the BVIEC or Delta had not complied with. Or Delta had not been compliant with.
So you agree, do you, that it is possible for Delta to import on behalf of BVIC, even though the ownership of the oil remains with Delta until it hits the tank?
Well, it would be possible to do that, but it would only be possible to do that without incurring liability for the payment of duty if Delta complied with the conditions which are imposed by the Commissioner, which they did not do.
Yes.
The directions, like you say, are conditions imposed by the Commissioners for the purpose of Section 69.
Yes. Because the Section 69 situation, which is, if you like, the way in which, if this is deemed to be fuel imported on behalf of BVIEC and Section 69 applies, then it does bring in the Commissioner's ability to impose conditions. And this is an aspect of the case which we say is clear. The conditions which the Commissioner imposed on...
Does it matter that Section 20 of the Ordinance doesn't have that phrase about subject to conditions as may be prescribed?
But that's when it's by.
That depends on whether one's properly looking at this being a situation of importation by BVIEC.
I agree. I totally agree. If that is the right analysis of this, then the conditions don't qualify the freedom from duty under Section 20.
If that's the right analysis.
If that's the right analysis.
Yeah.
If you go back to 69(1)(d), you're saying freedom from duty means is subject to complying with the conditions, and the conditions are what? The letter of July?
Yes,
July 1992.
yes, as indeed accepted by the respondents,
Yeah.
as we know from the judgment.
As per letter of July.
There was no mention of Section 69 before the judge, was there? It's going to come up rather later.
Don't think there was.
Can you just
it obviously
show me the conditions again, please? What's the reference to this?
it's the letter is at various places. I think it's about page 97. Is it?
97.
I'll just make sure that's right. Yes, 97, 98.
Yeah.
But I think what was being put for me as BVIEC being the importer, that would be inconsistent with Section 69. Because one would either have a situation where one never had a Section 69 situation if the eventual user of whatever was being imported was to be regarded as the importer.
But Section 69 surely contemplates importation where no duty is payable at all. The conditions bite, do they not, after the fuel has come into the BVI? And if that is so, it's difficult to see how Section 69 can have any practical effect.
In the present case or at all? I'm sorry, I shouldn't again ask questions.
Well, I don't mind you asking questions. It won't be guaranteed an answer, but, well, take both.
But Section 69 expressly does envisage a situation where both is where view is not only entirely but also partially free of duty.
Yes, but my point is a fairly prosaic one, and that is, if you are importing free from duty, if that's to have any practical effect at all, the conditions cannot nullify that provision by imposing requirements to be fulfilled after the importation has taken place.
Well, I think I understand that, yes. I think I can...
What's the answer?
Well, I think I accept what...
Yeah, right. Thank you.
The judge continued. I think really it's simply a question of telling your lordships that the next important paragraphs, if you like, begin at 83, which refer to the importer being required to secure the authorization of a proper officer. And this is in the part of her judgment dealing with non-payment of duty.
Yeah.
And she says, given that no duty had been paid on the fuel prior to its removal from its place of importation, if the respondent is to avoid the legal consequences which would follow, it would need to demonstrate that it was otherwise permitted to do so. And then she refers to the point of the evidence which I've already taken you to, I think, that the approval for the discharge of fuel is distinct from tank number 7 to the Electricity Corporation, is distinct and separate from permission to discharge fuel from the vessel to tank number 7. And he says that the applicant failed to notify the Customs Department of the intended discharge of fuel to tank number 7 and failed to secure permission or authorization. And the discharge process was carried out in the absence of customs officials who appear to have been informed only after the fact. On the controverted evidence of the parties, several facts are immediately clear. First, it's apparent that Mr. Letson had been in contact with at least 2 customs officials, including the Assistant Commissioner of Customs. It was apparent that the respondent, that's obviously a mistake we always make from time to time, of putting the wrong party in. The respondent was well aware that it needed to notify and obtain the requisite authorization. And then refers to the emails. The attempts made by Delta at paragraph 90, the judge rejects the argument made that in the circumstances the there was any implicit permission on behalf of the Commissioner. And she says, effectively, they knew the law. There was nothing there which amounted to an estoppel. And at 95, she says why there are obvious reasons why the legislature and the Commissioner had mandated the need to secure the imprimatur of customs officials. She refers at 96 to the argument that the respondent had left the Commissioner in doubt as to the actual amount of fuel which had been removed and the actual destination of the fuel. And she then, as we would submit, correctly refers to the test she had to make as to whether the fuel was indeed liable to forfeiture or not, and that she couldn't take a generous view. And I think your lordships have already referred to the fact that she was somewhat unhappy with the situation, but felt in the circumstances that the strict view had to prevail. My lords, the question probably does turn into a fairly narrow one as to who was the importer.
Yes.
If it was Delta, Section 21 of the ordinance, the electricity ordinance, doesn't entitle Delta, it only entitles BVIEC to the concession.
Yes.
It may have been somewhat bedeviled by sloppy language in the courts below, but the Commissioner clings to the position that the importer was Delta, liability for payment was Delta's.
Yes.
And in those circumstances, the consequences follow. And it follows that the very curtailed arguments in the Court of Appeal mistook the analysis, which we say was correctly undertaken by the judge. The Court of Appeal was wrong as to who was the importer, and so the person liable for payment. Well, there's just one other matter.
Before you go any further, I mean, okay, there's this issue about the identity of the importer, but putting that on one side, if we've got fuel in a tank which is owned by the electricity company, what is the jurisdiction of the Commissioner to have that forfeit in circumstances where the only arguable default has been a paper default by Delta,
Well,
in not having on a paper basis paid the duty that it will get back?
Well, it follows from the obligation for payment of the duty, which is imposed by the Act. The Act requires the owner to pay the duty. The owner at that stage, as we say, being Delta. If Delta is liable to forfeiture, Delta is liable for the goods to be forfeited. It makes no difference, we say, that it has been put in the tank which is earmarked for BVIEC, or the title has passed to BVIEC.
I mean, liability to tax has got to be clear, hasn't it,
Yes.
Mr. Guthrie?
Yeah. Well, Section 31A is clear.
Well, you'd have thought that if people owned fuel where they should have paid duty and haven't, then one can well understand forfeiture. But we're talking about the taking of a third party's property here. And one would be happier to see a clearer endorsement in this Act of jurisdiction to do so.
Goods impounded by customs are often impounded in circumstances where their actual ownership is not particularly clear. I think some of your lordships, in any event, will recall the case which is mentioned by the judge in her judgment EastEnders cash and carry. I think
Remember it
Lord
well,
Reed, yes.
But
And
forfeiture generally is of the goods. The fact that the as it were, the guilty party has sold them swiftly before the van arrives to impound them doesn't generally exempt them from forfeiture, does it?
no, well, it wouldn't in this case, as we say, if we're right about it. The fact that the goods have got into the tank and so title is passed under the contract would not remove the entitlement to forfeit. I should say, your lordships will have appreciated that the version of EastEnders cash and carry current when the judge delivered her judgment predated your lordship's consideration of the case.
I don't think there's nothing in it which helps apart from sort of general approach.
Well, there's nothing in it which, in fact, the judge probably took a slightly sterner view of what had to be established before the case was, before forfeiture, than she might have taken now, but we're quite happy with that. I mean, we say that they were liable for forfeiture full stop, and no question arose.
It just shows that these forfeiture provisions go back a long way and can be very draconian in their effects.
Yes, the only, well, I was going to say one thing. The case which has been included in your bundle is not the case she referred to, but the subsequent coda to it, which just involved costs. I don't think it's necessary for me to substitute the right case in the bundle, but it's available for you with your associate if you should need it. I did, however, I was going to refer to one aspect, because I don't know whether it's a point which would be taken against me at any length. I don't think so, but certainly the respondent's case refers to the need for the notice of seizure to correctly identify the basis upon which the seizure was made, or on which the goods were liable to forfeiture, which I would respectfully submit is not a good point on the respondent's part, on the authority of the law as it stands and as explained up to and including the EastEnders cash and carry case. And you'll recall in this case, we looked at the notice of seizure and it referred to the failure, lack of permission. It's at pages 73 and 74. And it referred to the lack of obtaining, the failure to obtain permission and the absence of customs supervision. And as you know, that the basis upon which the case was decided in our favour was not that basis, it was the basis that payment of the duty had not been made. In answer to such an argument, you have in the bundle the recent Supreme Court authority at page 479, I think, of the authorities part of the record.
Which paragraph do you want to repeat?
The relevant paragraphs are at page, begin at page 490. Those of your lordships who remember it will recall that there was quite a series of judgments underlying it, and they began with first instance decisions of Mr. Justice Singh, at letter H on 490, it refers to the first of those judgments about the detention being unlawful, and then the second, and over the page at paragraph 11 of the judgment. In his third judgment, Mr. Justice Singh was concerned with the seizure notices. The question was whether a statement in the notices that no evidence of UK duty payment has been provided was a sufficient statement of the grounds for seizing the goods as liable to forfeiture. the judge held that it was. There's then reference to the Court of Appeal in the first sentence of the next paragraph. And in the last, between letters E and F, first stop appealed, the Court of Appeal upheld Mr. Justice Singh's third judgment, and no appeal on the adequacy of the notice of seizure is before us. However, I did go back to look at the Court of Appeal decision, and I've had it separately provided for your lordships. It's a decision, I just allow lordships to be shown that. It's a decision
Yes.
of Lords Justice Jackson, Lewison and Bateson, at paragraph 20.
Thank you very much.
Which refers to the third of Mr. Justice Singh's judgments. In it, the judge rejected a challenge to the Commissioner's decisions to seize the goods that were not the subject of the March 2012 judgment, that is, goods seized before 4th of November. He rejected First Stop's claim that notices stating...
House of Lords judgment.
I think my learned friend may not have got the right authority in front of him. I don't know that I need really read the whole of that paragraph.
Yeah, just tell us what the point is.
Well, the point is really explained later on in the judgment. In paragraphs 36 to 38, basically the Court of Appeal is saying that a challenge on the basis that the notice did not accurately state the reason doesn't matter because, and I think the paragraph I rely on is paragraph 37, a notice under paragraph 1 of Schedule 3, which is similar to the notice under the British Virgin Islands legislation, not a requirement for the exercise of the power to seize. Paragraph 1.2 of Schedule 3, to which I've referred, identifies circumstances in which there is no need to serve any notice at all. Even where a notice is required, there is no requirement that the notice be given at the time of the seizure or decision to seize the goods. The lawfulness of the decision is a matter that will be decided in condemnation proceedings. The consequence of not serving a notice or serving one at a later stage relates to the time from which the goods owner will have to serve a notice under paragraph 3 of Schedule 3, claiming that the goods are not liable to forfeiture. In effect, I think what it means is that it's not crucial to be accurate in the notice of seizure because the lawfulness or otherwise will be decided in the condemnation proceeding.
Yes.
My Lords, I think I've taken you to the material that I want to take you to.
Could I just ask you one clarification? On page 109, I'm not sure whether you showed us this or not, the affidavit refers to a letter of the 21st of January 1992, which sort of started this process. Do we have that?
We do now, my Lord. It's one of the exhibits to the second affidavit of Mr. Sylvester. I can show you that. I think that, no, I'm sorry, it's Mr. Smith. I'm so sorry. It's a different version of Mr. Smith's affidavit.
Mr. Perry Smith or Mr. Wade?
Mr. Perry.
Wade Smith.
Mr. Wade Smith. I'm so
Wade
sorry.
Smith, about halfway through the little bundle.
Yes. I don't know whether you have been handed a copy of that.
We have that.
It's the first of the...
I've got the letter,
yes,
thank you.
21st January.
All right, fine.
And I suspect that the important paragraph is at page 66 of the letter, which is the last page of the letter. The law requires that duty be paid at the time of importation on any goods subject to a duty charge. For many years, the importation of petroleum products has been regulated in such a manner as to permit a monthly accounting for duty on imported cargoes. This is a concessionary arrangement, and to permit the continuation of this concession, I require you to...
Well, I mean, that's what I was saying. I thought it's a concessionary arrangement, which doesn't comply strictly with the principle that duty is payable on importation, but is a concession which is subject to compliance with the conditions.
Well, I think that the intention of the July letter was to produce a similar situation.
Well, it was against the background of
Yes.
a concessionary arrangement which had been going on for many, many years and was being continued, but under slightly different conditions.
Well, as I say,
Anyway, thank you.
unless there's anything further that your lordships would like to ask.
Is that letter of 1992 about duty-free imports?
Subject to review.
Or arguably duty-free imports? In other words, is it about the electricity companies' freedom?
Well, all I can
freedom
say is
from
that
duty?
it was specifically referred to in the subsequent letter, which plainly was.
That was, certainly, yes.
But it does mean that if the concession is that you don't actually pay duty at the time of importation, but do it later under these arrangements, then one can see how the question of whether it's a BVIEC oil can come up later and not at the time of importation.
Yeah. Yes, this is about all their ordinary importations, isn't it? And it's about a running account, effectively.
Anyway, thank you. That's all.
Well, unless there's anything.
Thank you very much indeed, Mr. Guthrie. Now, Sir Fenton.
Oh, my lord, prior to the enactment of this Virgin Islands Electricity Corporation Ordinance in 1979, the colonial government ran the electricity undertaking as a government undertaking. One would have expected that at that time, the fuel which was used to generate electricity for the territory would have been free of duties. The government would not charge itself duty. So the colonial government decided later to establish a corporation and to transfer the entire government undertaking to that corporation. And at that same time, by the same legislation, they provided that the corporation was to be entitled to import duty-free fuel for the generation of electricity. Well, that was passed in 1979, and in 2008, there was this letter. I hope your lordships have it. It's referred to in paragraph 63 of the judge's judgment. In that letter,
Where do we have that then, Sir Fenton?
in that letter,
Second affidavit of Sylvester. Second affidavit of Sylvester.
what? How to find it?
It's, my lord, it's the second affidavit of Bevis Sylvester.
Second of affidavit.
Yes, the loose copy. And it's the first exhibit.
Second affidavit of Sylvester. And the date is 25th of August 2008, is that right?
That's
yes,
correct.
it's the first exhibit after the affidavit itself. Yes, we have it, Sir Fenton.
We're delighted.
Yep.
It says, additional storage, BVIEC, the Delta Petroleum Plant, Popwood Pond. Now that is where Delta has all of its tanks, because it does business commercially using fuel for gas stations, and it supplies the corporation for electricity for the territory. That correspondence is regards the above caption in which you are requesting that tank number 7 within the Delta Petroleum Plant at Popwood Pond be added to the BVIEC storage tank farm for an additional 250,000 gallons. Please be advised that the BVIEC's pipeline must be utilized at all times for the delivery of fuel to the BVIEC. However, as a means to facilitate legitimate trade, we will give permission to utilize tank number 7 under special requirements established and approved by HM Customs for additional storage and delivery only to the BVIEC. This is a privilege, and any contravention of the laws and guidelines of customs may result in the loss of such privilege. Now, so tank number 7 became part of the storage tank farm of the Electricity Corporation. So when on the 29th of August 2012, MV Charmer, the motor vessel, came in with 122,000 gallons of fuel. The intent when it left St. Kitts Nevis was that that fuel should be put into that tank number 7 when it arrived in the British Virgin Islands. It came in, and they tried to unload it, but there was not success. And because the vessel needed to leave the territory, the officers or the servants working for Delta allowed the MV Ocean Princess, who had also delivered fuel into the tank, to have its hose used to deliver the fuel which was in the motor vessel Charmer into the tank. So the fuel was all deposited into the tank. My submission, my lords, is this, that fuel, when it left, came into the territorial waters. But there was no question of duty until it is landed. Until it is landed, there is no question of payment of duty. That doesn't arise under the law. The goods have to be landed in the territory. If they were unable to unload the fuel, Delta could have sent the vessel back to St. Kitts or wherever. But the vessel discharged the fuel on land into the BVIEC tank farm, tank number 7 in particular. So my submission is that the duty-free status of the fuel which was discharged was concurrent with its discharge from the MV Charmer into tank number 7. That's the submission. The duty-free status was acquired concurrently with the discharge into that tank. And therefore, the seizure was seizure of property of the BVI Electricity Corporation under arrangements which lasted for years and which everybody knew would result in vessels bringing in fuel and discharging it into that tank. The Ocean Princess also, in those days, delivered fuel, but that the commissioner didn't seek to seize the fuel from the Ocean Princess. He said, well, the fuel from the MV Charmer was dutiable, no duty was paid, and it was liable to seizure, and it was mixed with the fuel in the other tank. So he can seize the whole tank with all the fuel, all of which was imported for and on behalf of the Electricity Corporation. My submission is, my lords, that Section 20 was triggered, and it was triggered concurrently with the deposit of the fuel into tank number 7.
Yes.
And for that reason, we say that the seizure was not correct and that the Court of Appeal were right to say so.
Yes.
Okay.
Thank you very much.
Just two things, please, Sir Fenton. I expect I'm behind the pace.
Well, our cross-appeal, my lords, depends upon whether we can succeed in showing that the fuel was not properly seized.
Yes.
And if that is the case, then the Court of Appeal, we say it's an oversight. They should have directed an inquiry into what loss we had suffered. And in respect of costs, I am proposing the other side. The commissioner said on appeal that if he succeeded, he wanted costs in the Court of Appeal and in the High Court. Yes. We said the same thing. I repeat that again today.
Yes.
If whoever succeeds, the cost should be in all three courts.
Ms. Patel, are you going to follow?
I am, my lord.
Yes. Anthony.
May I ask two things, please, Senator? And if Mr. Patel ought to deal with them, please say so, and I'll repeat them then. First, could you look at section 3 of the Customs Act, which is on page 342?
I have it.
Thank you.
Have it,
I'm thinking, perhaps wrongly, of section 3(2)(a).
Yeah.
Time of importation of goods shall be deemed to be ... when the vessel comes within territorial waters. Now, your submission just now was that's not right, that there is no question of duty until the fuel is landed.
Yes.
How does that argument
I say
stand with
that
3(2)(a)?
The correct interpretation of that is, yes, the fuel is imported when it comes into territorial waters, but it is not dutiable unless it is landed on the territory. Were that not so, and Delta had decided, because the hose could not allow the fuel to be landed, to send back the ship, would Delta have been responsible for the duty?
So, right, so you say it is imported, but it's not dutiable. I follow, right. And the other question is about the
It's not indutiable until it's landed. And when it's landed, the duty-free status is acquired concurrently with the landing.
Got that. Now, the other thing is just the proposition that this was always intended for BVIEC, for the electricity company. Yeah. Could you look very kindly, Mr. Sir Fenton, at page 99 of the main bundle, and then have open at the same time Mr. Sylvester's second affidavit, which is the loose copy, came this morning, and which has towards the back another document also headed manifest. And let me just see, they're not numbered, but it's 1, 2, 3, 4, 5 pages back.
9, yeah.
And it's got a number, looks like 2209 in handwritten on the top right-hand side.
Sorry, my lord. Ours seems to be a little different to that one.
My lord, may I inquire what page my lord is looking at?
Numbers, I'm afraid, but it's...
Yeah, we'll make sure that he gets one.
It's about 5 pages from the end of...
I think that's the Ocean Princess.
It is the Ocean Princess.
Oh, I do beg your pardon.
It is the Ocean
In that case, I needn't trouble you.
The
I was looking...
Well, is there not a question to be raised here? Because if we've got the two manifests in front of us, Sir Fenton, the column at the to the left is name of importer, I assume, and for the Ocean Princess,
Yeah.
We've got the electricity company as the importer of 295,000 gallons of diesel.
Yep.
But when we look at what the Charmer had, we don't find any electricity company as being the alleged importer
That's the point.
of the diesel. It's all Delta. So how does that fit with the argument that it was the electricity company which was importing the diesel on the Charmer?
I think that the true position would be that Delta was importing the fuel for and on behalf of the corporation. And so BVIEC did not charter the vessel. The vessel was chartered by Delta. And that is why the manifest is written up like that. Delta
Well, Delta didn't charter
is
the ocean.
importing, Delta is importing 122,000.
Did BVIC charter the Ocean Princess?
And the final mine manifest, there's a final manifest for the Charmer which says that the diesel, 117,000, is bonded.
Where's that?
I think we may not have that yet.
That's a couple of pages before, my lord. I think it's the third
Two
exhibit.
pages before.
Yeah.
And that's the amount of fuel which caused the dispute.
To at paragraph 6 of the witness statement.
I couldn't hear that.
It's the manifest to which Sir Fenton is referring is 2 pages before that.
In the Sylvester
Yes,
affidavit.
in the Sylvester affidavit,
Yeah.
It's explained at paragraph 6 of the witness statement.
paragraph 6 of the witness statement. Yes.
Right.
Well,
And was sent to customs, was it?
yeah. It may be perhaps we'll hear from Ms. Patel now.
Yeah.
Thank you very much indeed, Sir Fenton. It's very nice to see you again. Thank you.
We are right.
Yeah, thank you.
Right,
Now-
my lord.
Now, Ms. Patel.
Got it. Yeah, go on, Nina, go on. Go on, Nina.
My lord, on the first issue and whether the dispute...
Could you, can we just clear up that last point? Because I'm still not sure I got the right
Yes, of
document.
course. So the question from my lord was why...
Well, we got paragraph 6, which refers to the final manifest, and you were going to show us where the final manifest was, or you may have shown my lord's.
The final manifest is 4 pages in from the exhibits at the back of Mr Sylvester's second witness statement.
1, 2, 3.
Headed manifest.
That's the one for the Ocean Princess?
No. My version, the first document should be the 2008 letter. The next document should be marked Territory of the British Virgin Islands, then a tanker discharge report,
Yes,
and then a manifest, name of vessel, the Charmer.
yes. And the point about that is it's got 117,000, which is bonded.
Yes.
And is that...
So the manifest that was referred to in Mr Smith's affidavit that we saw a moment ago had fuel listed against Delta as the importer. And that was a manifest that was submitted before the Charmer came ashore.
Sorry, I'm not with you. We've got the manifest, which has 117,000
Yes.
as bonded.
Yes.
15,000?
117.
17,074 and 56.
But where does it say that's bonded, imported solely for the use of the electricity corporation? which is what the affidavit says.
My Lord, is the manifest doesn't say that, but what the affidavit says is that this final manifest,
Is it clearly stated there?
There's another one further on.
my Lord is quite right, that is not on the face of the document, but bonded is to be understood as meaning intended for tank 7, a bonded tank. So it's clear from this manifest that this fuel wasn't for Delta. It was destined for a bonded tank. It was bonded fuel.
But that's the one, is it dated the 17th of September?
Yes, and that we see from paragraph 6 that was...
Is it the day after unloading?
It is the day after unloading.
Right.
It's 3 days prior to seizure.
On the other hand, 2 pages further on, you've got one with only marginally different figures, which is dated the 25th of July. I'm sorry, it's my fault. I hadn't noticed that there were so many manifests.
One would imagine that the one dated the 25th of July was referable to a different importation. You'll recall that there was a prior trip
Earlier
to the BVI.
Earlier visit, maybe.
Yes, that's paragraph 5 of the SFI.
Yes.
Right.
But what Mr. Sylvester says about that, he relies on the final manifest in support of the proposition that the defendant is stopped from disputing that the procedure which it had always accepted was incorrect, or that it was not aware that the fuel was designated for bonded tank number 7, and that second proposition remains the case. The manifest does show that the fuel was bonded.
Well, by then it was in tank 7.
By then it was in tank 7. But it is relevant that this document was with customs before the seizure was effected.
There's no finding about this document, is there?
There is no finding that I've seen, my Lord.
There's nothing in the statement of facts.
Was it even referred to in the proceedings below, this particular manifest? Well, I suppose it must have been if it is exhibited to Mr. Sylvester's affidavit.
This is the affidavit which took us all by surprise yesterday.
Oh, I see. Well, the surprise continues.
I haven't...
But it was sworn in November 2012, so why it should have been the cause for surprise is another matter, but let's not trouble about that.
There is, my Lord, a finding in the Court of Appeal. There's
Is there?
reference to it in the Court of Appeal
Right.
judgment at 174.
174.
If it's BS 17, which according to Mr. Sylvester's paragraph 6 it is, there's a passing reference to it in Mr.
Well, I think I might
Letson's
BS 17 is clearly marked as such slightly earlier in the exhibit.
So it's not.
It's the second document. And in fact, I think that it's, in fairness to Mr. Sylvester, it's that document which he says is clearly stated. Because you'll see, this is a document which apparently came into existence, well, it's signed over the date of the 17th of September at the foot of the page.
Where are we now? Back to Mr. Sylvester's.
It's Mr. Sylvester's exhibit to his second affidavit.
Yeah.
It's the second document in it. And I think it's that document to which he refers.
Oh, yes, I see that. It's BS 17 at the top.
And you'll see
of the
that
document.
written across it in the middle, his list is imported
Yeah.
solely.
I see.
But I am in some difficulty about this affidavit because I don't know why it's not in the record.
Well, presumably your client has had it.
Well, I don't know because I haven't been able to contact him since I've seen it.
So who produced it yesterday?
Mr. Sir Fenton's client.
Yes, but it is an affidavit apparently sworn in the proceedings.
Well, yes, I think that's plainly. I mean, I've no reason to be suspicious about it.
No, well,
I don't know whether it was before the judge, and I know my learned friend says it was referred to in the Court of Appeal. I was just going to look at that.
right. Well, let's. Ms. Patel refers 174. You say, Ms. Patel.
174 of the
Which
Court of
line?
Appeal judgment.
Which line?
22.
32. And who's speaking at this stage?
This is counsel for Delta.
I see. Yeah, I don't think council refers to an actual document. He does say lodge the final manifest on the morning, but
Yes.
I don't know that he produced that to the court, did he?
That is the only document which is of that date, which could conceivably be consistent with what he says about it.
Well,
And if you look, I'm fairly sure Mr. Letson had made a reference to it in his affidavit. Yes, page 84. Paragraph 8. Last 3 lines, 4 lines. I had submitted BS 17 of the Sylvester affidavit with the clearance documents on the 17th of September. Now, are we to take it that that's a reference to documents which included this manifest?
Well, the manifest to which Mr. Guthrie has helpfully referred us just now is headed BS 17 in handwriting at the top.
Well, that's
so I think on that basis, I'm bound to accept that that document was before the...
Yeah, thank you very much. That's very helpful, Mr. Chairman. Right, after all that squirreling about, where are we?
My Lord, while we are squirreling about, can I just give you some references in relation to the other 2 exhibits?
Yes.
Which arise from the new affidavits, just to clarify that they were before the lower courts.
Right.
The 1992 directions that we've looked at, exhibited to Mr. Smith's second witness statement. Those are referred to in the judgment, the High Court judgment, at paragraph 83. The last sentence refers to directions which were issued in 1992 and 2012.
Just, what's the electronic reference to?
151, page
151. Thank you very much. Yes.
And in relation to the 2008 letter, which was the letter attached to Mr. Sylvester's second witness statement, that is referred to at paragraphs 77 and 79, again of the High Court judgment on page 149.
Yes. Yes.
That is all the squirreling about I propose to do. Can I then just deal with 3 points on the first issue? Was the disputed fuel dutiable? Where we are, in my submission, crystallises into 3 questions. Did Section 69 of the Customs Act 2010 entitle Delta to import fuel on behalf of the corporation, duty-free, subject to conditions? And I understand my learned friend to have accepted that proposition. Secondly, did Delta, in fact, import this fuel on behalf of the corporation? And thirdly, was its entitlement to import that fuel on behalf of the corporation affected by the 2008 letter, which I understand my learned friend relies on as the entirety of the conditions in this case?
Yes.
So The first point having been conceded, on the second point, did Delta import the fuel on behalf of the corporation? It's Delta's case that it did, and that is clear from a number of pieces of uncontradicted evidence.
There's no finding by the judge that it did. You're asking us to make some primary finding.
Well, what there is from the judge, perhaps we can start with that, is there is a sentence at paragraph 96 of her judgment. The last sentence, she says, the fact that the discharged fuel was intended for the corporation and would eventually have attracted a duty-free concession has clearly provided little comfort to the applicant in the circumstances. Now, we say that implicit in that sentence is, in fact, a finding that the discharged fuel was intended for the corporation.
Intended when? Rather, intention formed when?
Well,
I think you can say it's not inconsistent with the view that it was imported for BVIEC.
no, and in fact, the rest of that sentence, which refers to a duty-free concession being subsequent rather than prior, would suggest that the intention was there for all purposes
At the time of importation.
at the time of importation.
What do you
Notwithstanding
say?
page 99.
Yes.
What does on behalf of mean? Is it enough that it's intended for the corporation, or must it be on behalf in the sense of as their agent?
I'm sorry, my lord, can you clarify
No,
the difference?
what does on
between-
behalf of mean? Does it imply some sort of agency arrangement, or is it enough that the ultimate purchaser is intended to be the corporation?
Well, in this case, Delta would satisfy both of those requirements because Delta was in fact the agent conducting the importation. But also,
It wasn't acting as agent for the corporation, at least we haven't got any finding that it was acting as agent. It was acting as an importer who was going to sell it on to the corporation. You may say that's enough, but it's not a sort of agency. Really.
we would say that is enough because, particularly in circumstances where the importation is taking place by way of discharge into a bonded tank, at which point the fuel becomes the property of the corporation. We have seen the 2008 letter that my learned leader pointed out, and that letter demonstrates that bonded tank number 7 was expressly approved by the Commissioner for this purpose, namely for storage and delivery only to the corporation. That's what the letter says. So in circumstances where the importation was taking place through discharge of fuel directly from the vessel Charmer into a tank which was bonded precisely because it was only to store fuel that was intended for the corporation, it follows from that the only logical analysis of those facts is that the fuel was imported on behalf of Delta for the corporation. And indeed, we see that reflected in the supply agreement as well. We looked at one clause of the agreement earlier this morning, but I'd just like to
This one.
yes, turn up another clause. The agreement, clause 3.5 of the agreement, which is at page 20. and it's here we see the reference to the bonded tank. The seller shall supply and deliver number 2 diesel fuel to Pockwood Pond Power Station so as to ensure the buyer's storage tanks are maintained at all times at a minimum level. The seller agrees to maintain, at the seller's expense, a bonded tank filled with a minimum 100,000 US gallons of diesel at the seller's premises at Pockwood Pond. So that is Delta agreeing to maintain a minimum capacity in the bonded tank number 7. The parties agree that HM Customs in the BVI shall retain custody of the keys required to open all valves to this tank, and the fuel will be reserved solely for the use of the buyer. And so what we see from that is that not only was this bonded tank, although the tank itself belonged to Delta, Delta was agreeing, pursuant to this agreement, to maintain the tank with fuel, which was intended entirely for the use by the corporation. And the reason the tank, my learned friend referred to this morning, the reason the tank is bonded is because, in fact, while the fuel is in the tank, no duty is payable, reflecting the entitlement of the corporation. But my learned friend was quite right to point out that although certain bonded storage containers would perhaps typically require payment of security in return for the bonding, this tank didn't have a security against it precisely because the fuel, when discharged, wasn't dutiable. Now, we also see from the agreement that Customs had the keys to the valves to the tank at all times. This, again, is consistent with the intention of the tank as a storage vessel for fuel on which no duty has been paid, and where it is to be discharged for the use only by the corporation. And we see that the fuel was indeed discharged into this tank, as we saw at paragraph 96 of the judgment. And if we put these factors together, we have fuel being decanted from the vessel directly into a container, which is reserved, the contents of which are reserved solely for use by the corporation. We have only the Commissioner having the keys to the tank. And we have the final manifest, which was submitted on the 17th of September, and the accompanying documents, making clear that 117,000 odd gallons were bonded, consistently with its discharge into that tank. And the document that my learned friend directed our attention to, making clear that that fuel was imported solely for the use of the corporation. In my submission, it's very hard to put any other factual complexion on that set of facts other than this fuel was intended for the sole use by the corporation, that was apparent at the time of importation, and that therefore Delta imported the goods on behalf of the corporation, being the person who was entitled to full relief.
I think it looks as if it's fair to say that that was the basis on which the case was argued on behalf of the commissioners before the judge. Looking at paragraph 70 of her judgment at page 148, in the second last sentence, one sees reference to fuel imported on behalf of the BVIEC being used in relation to fuel intended to be sold to the BVIEC by Delta. So the way the case was argued certainly seems to have been that on behalf of wasn't confined to a strict relationship of agency.
Yes.
So really, Section 20, corporation shall be entitled to import free of duty, etc. Well, the corporation isn't an importer itself.
No.
This means the corporation shall be entitled to cause to be imported free of duty. Is that right?
That's right, my lord.
That's why I thought you relied on Section 69 as bringing in Delta, not 20 itself. Or maybe you rely on both. I mean, you can do.
I do rely on both, my lord, because all Section 69 does is Section 69 1D.
Well, the difference is that Section 69 brings in the conditions of it.
It does.
Mr. Guthrie relies to some extent.
It does, but as I'll come on to in a moment, we say that that is no answer because of the nature of the conditions relied on.
But anyway, in answer to my lord, you say you rely on Section 20 in any event.
In any event, yes. And before we leave the agreement, there's I'd also like to refer to clause 8.5. Which makes clear that in relation to the price of the fuel, the prices paid by the corporation to Delta are exclusive of import duties.
Well, that's pretty obvious, isn't it?
Well, it would be very...
This is an agreement between Delta and the electricity company.
It is, but it would be very strange if Delta had agreed to an agreement that excluded from the price any payment in relation to duty in circumstances where it was accepting that it itself was going to be liable in the short run to pay that duty, albeit subject to a refund, as the Commissioner contends. One might have expected there to be some mechanism in the contract reflecting the fact that Delta was going to be liable for duty under what is said to be an established procedure.
What is Delta's position about the assertion that you were in fact liable and you obtained refunds?
Delta doesn't accept that there was the established procedure contended for by the Commissioner.
There isn't actually any evidence about it from Delta at all.
That was found by the judge that they did agree.
Yeah.
What there is in the Court of Appeal, my Lord is right, there isn't any evidence contradicting it, but what there is in the Court of Appeal judgment is a discussion.
Judge, paragraph 71.
Let Ms. Patel tell us what the Court of Appeal says, and then we'll go back to the judge. That's what you're telling us? The
Court of Appeal judgment demonstrates, reflects submissions from Mr. Neal, counsel for Delta, explaining why there is no evidence. And it essentially relates to the Commissioner's evidence having come in very late before the hearing. He explains why it was that there wasn't any evidence.
Yes, but as my Lord points out, you've got a finding against you to contrary effect by the trial judge.
As to the existence of a refund procedure?
Yes.
Yes, we do. But in any event, we say that the existence of a refund procedure couldn't lawfully be a condition conditioning the entitlement that's bestowed by Section 69 1D.
It looks as if it's a running account in any event, doesn't it?
Yes.
So that it's a paper transaction.
Well, we've heard today, I must say I wasn't aware of the mechanics of it.
I think it
but
follows from, I don't know.
The 1992.
It follows from the 1992 letter, but perhaps it doesn't.
A monthly accounting duty, my Lord is
Yes.
right. It's unclear whether the 1992 letter has been superseded by the 2008 letter. And my learned friend puts his case on the basis of the 2012 letter.
Yeah, July 12th.
Yeah. But in any event, Section 69 would require any conditions imposed to be consistent with the entitlement that's conferred by that provision of the Act. And my third point is that it would be completely inconsistent with the object and purpose of a clause that intends to confer a duty-free entitlement on the importer or the person importing on behalf of the person with the entitlement to attach a condition which in fact negated the duty-free entitlement conferred by the clause.
Sorry, could we just go back a step? I interrupted you when we were about to refer us to something in the Court of Appeal. I thought we ought to start with what the judge found, which is against you. You said there's something in the Court of Appeal which goes the other way.
No, my lord, all I was saying in relation to that was that
there was an explanation by counsel why contradictory evidence was not laid on behalf of Delta before the judge. Is that it?
yes, that's it. I'm just trying to find the reference.
Oh, that takes us very far. Never mind, that's all it is. It doesn't take you very far.
Perhaps I can let you have the reference when I find it. Apologies. So in relation to the third point, what is said to be the established procedure cannot condition whether or not the goods were dutiable under either Section 20 of the Ordinance or Section 69. In relation to Section 20, it's clear on the face of the Ordinance that there is no reference to conditions. It's a straightforward entitlement. And in relation to Section 69, although the Act states that it is subject to such conditions as may be prescribed by the Commissioner, as a matter of common sense construction, any conditions thereby prescribed would need to be consistent with the terms of that clause.
Well, might it mean that you're in breach of the proper procedures under Section 29, not Section 30?
Well, exactly, my lord. We say that is quite right. The findings that we have in relation to the 2012 letter from the High Court judgment are to the effect that the directions in the 2012 letter prescribed conditions for the manner of importation into the territory. Namely, they are the sort of conditions that one would see fit to impose under Section 29 of the Act. You will recall, perhaps we can turn up the High Court judgment now, that these directions were only considered by the High Court in the context of the Commissioner's alternative case that was put on the basis of Section 31A and not 31B. And this is important because...
Sorry, these were considered in the context of 31B.
B.
Yeah.
The other way round, my lord. Apologies. And this is important because it is only now that the Commissioner seeks to pray and aid these directions in relation to Section 31A through the route of, it seems, Section 69. If we turn up the High Court's findings on the conditions, that's at page 142. We see reference at paragraph 41 to the 2012 letter. And we see at 43 the applicant's case was that Section 29 of the Customs Act must be read together with Section 31B of the Act.
This is all under 31B?
Yes. and the findings in relation to that start at 48. The court is satisfied the applicant cannot rely on the purported breach of section 29. She goes on to explain that the terms of section 31B make clear that the conditions are no answer because any restrictions need to be in force under or by virtue of an enactment, and of course the 2012 letter is not such a thing.
In fact, it doesn't even comply on the face of things with the requirements of a direction under the Act, which are in section 11.
Quite. She goes on to say that she makes the point at paragraph 51 that section 29 doesn't impose a penalty of forfeiture. It in fact imposes what are clear criminal penalties. And so it wouldn't have been consistent with the Commissioner's case forfeiting the fuel to have lawfully based that forfeiture on a breach of section 29, because if section 29 had been breached, the proper course for him was in fact a criminal penalty and not forfeiture. And then at 52, she says the clear import of the issued directions is to prescribe conditions dealing with the manner in which petroleum fuel is to be imported into the territory. They establish operating procedures which are geared to ensure what is termed a smooth importation process. The directions do not purport to impose any prohibition or restriction in respect of the importation of fuel into the territory. And we say that is entirely consistent with the terms of section 29. If we look at section 29, section 29 is at 363 of the bundle. And section 29(1) makes clear the Commissioner may by direction in writing impose conditions and restriction in respect of, for example, the movement of imported goods between the place of importation and a place approved by the Commissioner for clearing of the goods out of charge. And the judge found that the clear import of the directions was entirely consistent with that. They prescribed essentially conditions in relation to the movement of imported goods, the manner of importation. And we say that that's right, that the conditions in the 2012 letter do relate to the movement of the goods. And to the extent that enforcement of those conditions was appropriate, the mechanism for that would have been through the criminal penalties under section 29 of the Act, as the judge found.
That could then result in forfeiture.
Well,
under section 29(5). I mean, it's not the route they've chosen, so it may not matter, but under section 29(5), you can get a fine and the goods can be subject to forfeiture.
yes.
But it doesn't impinge on the duty-free status, you say?
Indeed, my lord.
Yeah. I mean, it's not the route they've chosen, and so
No.
you don't have to deal with it.
No. My Lord Kerr is quite right. What we say the Commissioner is seeking to do is to elide conditions which sit properly under section 29 with the reference to conditions under section 69, which would be of an entirely different character. And then it simply cannot be right that a statutory entitlement to duty-free fuel can be cut down with the effect that the fuel is in fact made dutiable by virtue of conditions such as those relied on by my learned friend. It is also relevant to note that if we look at the 2012 directions themselves, there is no reference in the letter to Section 69 or Section 30 or indeed Section 20 of the Ordinance, there is reference to a number of mechanisms for enforcement. But the relevant provisions of the Act which are now prayed and aided by the Commissioner are not present, and that's page 76 of the bundle.
Did you say there was no reference to Section 29?
No, I said, apologies, my Lord, Section 69.
69, I see. Yes.
So were it the case that the conditions, the directions set out in this letter could properly be enforced through forfeiture under Section 31A, because, in fact, through the route of Section 69(1)(d), one would have expected to see reference here to, at the very least, Section 30, but more particularly Section 69 of the Customs Act, if it were said that these were conditions made pursuant to that provision of the Act. While we're on this document, it's also relevant to look at the terms of the directions that are set out herein. My learned friend referred to the reference to a new procedure in the first paragraph. And my lords have made the point that there is a finding in relation to the existence of such a procedure. But that, importantly, that paragraph, we say, doesn't form part of the conditions set out in this letter. The second paragraph, further to that discussion, the following conditions are hereby imposed, sets out through a number of bullet points what are said to be the relevant conditions. In order to render the fuel dutiable at the time of importation, there would need to be a condition within these bullets stipulating that, namely that the fuel would not be duty-free until such time as the refund procedure relied on had been fully complied with. But in fact, the conditions set out here relate to permission for discharge, attendance at the discharge, cooperation in relation to discharge, the manifest, completion of the discharge, and the time for that. And then the penultimate bullet that my learned friend took you to, imported cargo will be permitted to be released on a bond where necessary, provided that such bond is approved by customs and remains current. We've seen from the 2008 letter that there was an approved bond here, which remained current in the form of tank number 7 and the authorisation for that tank. And there's been no suggestion that that approval was ever revoked. There's then reference to the case, in the case of duty-free entries, an authorised person from the eligible entity must stamp and certify the cargo is for the sole use of that entity. Again, we say two things in relation to that. Firstly, the need for a person from Delta to stamp and certify that the cargo was for the sole use of that entity wasn't a condition under Section 69, it was a condition under Section 27. Because it relates to the manner of importation. But in any event, it was clear from the discussions, from the factors that I went through a moment ago, that notwithstanding the absence of such a stamp up to September the 17th and the manifest documents that we've seen, there wasn't any real dispute as to the purpose of the cargo, but certainly from September the 17th onwards, which was before the seizure took place, it was clear that the cargo had been certified for the sole use of the corporation. There's one evidential matter that I think it might be helpful just to go to, because I haven't gone to Mr. Sylvester's earlier statement yet. You will have heard, my lords, from my learned friend's submissions that Delta obviously made several attempts to contact the Commissioner prior to the discharge of the fuel. And I think it is right to note that amongst those attempts to contact the Commissioner, there was in fact a conversation on the 5th of September, which is important. If my lords can turn to page 6 of the bundle and paragraph 10 of Mr. Sylvester's first affidavit. Mr. Sylvester says, "I'm advised by Mr. Lettsome and verily believe," and we'll go to Mr. Lettsome's affidavit in a moment, "he notified Mr. Clinton Romney, an officer employed with the Customs Department, on the 5th of September, that the claimant would be attempting to discharge the fuel from the charmer to the bonded storage tank within the next few days." Now, what follows are some difficulties in relation to the date of discharge. We see reference in paragraph 11 to a letter advising that the Commissioner wanted to be present when discharge happened. We see at paragraph 12 reference to Mr. Lettsome advising that the discharge will take place on the September the 13th. And then we see in paragraph 13 that that doesn't happen. And then further attempts are made to discharge the fuel on the 14th, and then it takes place on the 16th. But the important point is that on Delta's case, the Commissioner was notified that the claimant would be attempting to discharge the fuel from the charmer into the tank number 7. The Commissioner was therefore notified on the 5th of September, prior to the discharge.
Well, is there any evidence from the Commissioner as to those averments?
There is, my lord. There is Mr. Romney's witness statement, I think is the best one.
Page 125.
Page 125.
Yeah.
Paragraphs 7 and 8. He doesn't accept that it was Mr. Lettsome who telephoned him. He says Mr. Lettsome indicated that he would notify me when the vessel would offload or discharge the fuel.
Oh, yes. Well, then in paragraph 9, he refers to the...
Yes.
He calls it an email. Mr. Lettsome
Yes.
suggests that he wrote a letter. I mean, is there any significance to that, or is it accepted that it was an email rather than a letter?
I don't think there's any...
No. Well, perhaps not.
Well, whatever else Mr. Romney says, and he's clearly addressing Mr. Lettsome's, either Mr. Lettsome's affidavit or Mr. Sylvester's, because he takes the point about who made the phone call.
Yes.
What he doesn't say is it's not true that I was told it was going into tank 7.
No, it's not contradicted that the the fuel was intended for tank number 7, and that he was told that.
And that he was told it.
So we say that on the 5th of September, it was made clear, whatever the inaccuracies on the manifest at that time, it was made clear by direct communication between Mr. Letsom and Mr. Romney that the fuel was intended for tank number 7, and that what passed between the parties thereafter was simply in relation to the date of discharge and whether or not permission was given for the discharge, or whether or not attendance took place when the discharge occurred.
How much longer are you likely to be?
Not very long, my lord.
Well, not very long, maybe an hour or a couple of minutes.
I do need to deal very briefly, well, I'm in my lord's hands as to whether I need to deal with the cross appeal in particular detail.
Well, I don't think you need to deal with it in particular detail, but some passing mention of it might be appropriate. So we'll adjourn now and sit again at 2 o'clock.
Yeah, I'm not sure whether the cross appeal is it contested. That if
Well, I think if I lose on the appeal, there's not much I can say in opposition to the cross appeal.
I thought.
Right. So that relieves you yet further of the need.
But maybe she can polish it off in 5 minutes.
Can you finish in 5 minutes then? Don't feel under any pressure, because we've got to hear from Mr. Guthrie if he wants to reply in any event.
I would have asked for 10, probably, my lord.
Well, I think we'll adjourn then. Sit again at 2 o'clock.
I mean, it's a rumbling.